Hello, and welcome to Ipsy Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Michael Arjun Banerjee, a PhD student in jurisprudence and social policy at the University of California, Berkeley. We will discuss his draft article, No Trial Executions, Police Killings, the Eighth Amendment, and Transformative Proceduralism. So welcome to the show, Michael.
Thank you very much for having me, Brian. Really excited to be in conversation with you.
Yeah, me too. I'm really glad to have you on. I found your paper incredibly provocative and thought-provoking, and I can't wait to hear more from you. So, Michael, I was wondering, by way of situating our listeners in the sort of the project of the paper, I wonder if you could talk a little bit about what you mean by no trial executions.
Of course. Thank you for the question. In order to do that, Brian, if you don't mind, I might just back up about 40 years to when the famous criminologist Lawrence Sherman wrote his seminal piece on the penal aspects of police killings in an article called Execution Without Trial. And then decades later, you have the constitutional law scholar Jelani Jefferson Exum writing about the death penalty in the streets in her 2015 article by the same name. But these, important interventions notwithstanding, as I say in the paper, few people in the legal academy have really interrogated the penal dimensions of police killings. So I'm trying to draw on that literature and carve out some more space. In the U.S., as you know, Brian, the state kills civilians via two main mechanisms. There's, of course, the formal death penalty, what I call on the paper the post-trial execution, which is exactly what it sounds like it is. This is an execution that follows an arrest, trial, conviction, and sentencing, and usually some very lengthy appeals. And it's also administered by state officials in private death chambers. And then there's the informal death penalty, what I call the no trial execution. And this is an execution that follows no due process whatsoever. And it's usually administered in public by police officers. We usually refer to the no trial execution as the police killing. Now, through this essay, I'm trying to take these arguments offered first by Professor Sherman and Jefferson Exum beyond kind of just analogization. And so the idea is to place the police killing, the no trial execution, within the ambit of the death penalty.
Well, so, I wonder if you could talk a little bit about how the Supreme Court and how the legal system more generally conceptualizes execution in these two contexts differently. In other words, sort of what's the view of the state's role and relationship to post-trial executions, the ones that are, I think people are more familiar with calling them executions as a matter of sort of colloquial language, and the way that the state kind of conceptualizes no trial executions, as it were, in terms of its responsibility for them.
Absolutely. So, and this is one of the main aims of the paper. It's to kind of bring to our attention, as I see it, the fact that there's very little that separates the two kind of modes of state killing. But the state has, when it comes to the post-trial execution, has a great deal of responsibility. The state has to provide one with a lawyer. The state has to, give one a fair trial. And the trial, of course, has to be overseen by a jury of one's peers and so on. So you have all of these procedural protections that attach when the state tries to subject one to the post-trial execution. And that execution is thought of as being subject to Eighth Amendment scrutiny and regulation by the Eighth Amendment and its prohibition against cruel and unusual punishment. In the no trial context, the Fourth Amendment reigns supreme, and this might be useful for some listeners. But as you know, Brian, we get this Fourth Amendment standard in the no trial execution context from a very famous 1989 Supreme Court case called Graham v. Connor, where the state articulated its explicitly articulated its Fourth Amendment um, kind of analysis of police violence, deadly or otherwise, and that's where we also get the very troublesome and troubling reasonableness inquiry. So that's kind of how the courts have addressed it, broadly speaking. And one of the issues is, of course, that you end up getting a good amount of protections in the procedural sense when it comes to the post-trial execution, but you get none of those protections when it comes to the no-trial execution. And of course, the end result is the same, with a civilian being subjected to the punishment of death.
And this struck me as a really kind of interesting and important distinction between the way we kind of conceptualize the Fourth Amendment and the Eighth Amendment, in the sense that, there is this kind of reasonableness element to the Fourth Amendment, the way we think about the culpability and responsibility of the state. And we don't think of like there being a kind of a reasonableness element to the Eighth Amendment, at least not in the same sense, at least not in the sense of like whether the state is authorized to use deadly force in the first place. Is that right?
I think that's right. I mean, the Eighth Amendment says nothing about reasonableness, and now, of course, a court could read into the Eighth Amendment a reasonableness standard, but one of the great merits, I think, the virtues of the Eighth Amendment in this context, and many people warn me and would suggest otherwise. Many law professors have suggested otherwise, but I think one of the merits of the Eighth Amendment is that it has no reasonableness. I mean, reasonableness is not articulated in the text of the Eighth Amendment. And so because of that, we can kind of look to it to suggest that, this reasonableness inquiry can be avoided if we turn to the Eighth Amendment in the programmatic sense, meaning that we subject what I see as a state program to Eighth Amendment scrutiny without having necessarily to get to what would be a very burdensome individual standard, or I should say individual action standard, when it comes to the application of any given punishment. But what I mean to say here is that when on the programmatic level, we can avoid the reasonableness inquiry by turning to the Eighth Amendment rather than the Fourth Amendment.
So like kind of shift our constitutional frame, as it were, to say, we should be looking at this problem as an execution across the board, not as two fundamentally different kinds of executions, and be looking at it through this Eighth Amendment kind of frame that requires absolute fealty to constitutional obligations, as opposed to the kind of looser standard of the Fourth Amendment.
Mm-hmm.
Yeah. Well, so maybe you could talk a little bit about why you think the Eighth Amendment should apply in this context, or maybe even better, to kind of start by talking about what elements you think are necessary for the Eighth Amendment to be the relevant frame through which we should look at state action.
That's a great question. Let me give that some thought. Well, Brian, this is first and foremost, and maybe I should have said this at the outset. This paper is really not an Eighth Amendment paper. I'm happy to answer the question, of course, and thankful for it. It's not a Fourth Amendment paper, and it's also not a 14th Amendment paper. It's a paper that's more so about shifting consciousness than it is about procedure, although I have a good amount to say about procedure and the like. When it comes to, when we should attach or consider a governmental program or governmental actions in the Eighth Amendment context, I'm looking first and foremost to kind of a bottom-up understanding or theory of punishment. Let me just say this. From the standpoint of somebody subjected to a no-trial execution, there is very little difference to that person, whether it was conceptualized, and by it I mean the state action conceptualized by courts and as subject to Eighth Amendment scrutiny or Fourth Amendment scrutiny, because the end result is the same. The end result is the deprivation of life, And in this case, of course, it's without due process of law. In the
Mm.
paper, I say very little about, say, the Fifth Amendment or 14th Amendment, but of course, those amendments, which make up a suite of amendments that I have called the punishment amendments, have a lot to say about no trial executions. But what we're looking at here is end result, and the end result is the deprivation of life. And by the way, the deprivation of life for having done or not done something that the state, through its police, agrees with or disagrees with. So in that sense, in the kind of most basic sense, this is a bottom-up understanding of punishment. And from the standpoint of the one who is subjected to this kind of treatment, there's very little difference, very little to distinguish the two forms of state killing. So from that standpoint, the Eighth Amendment should apply where life is taken.
Mm-hmm. Well, that was one thing that really struck me, was like, I'd never thought about the sort of police action on the street as being kind of something that ought to be placed in the context of punishment as opposed to policing. But it does seem like it has a kind of a punishment or even a penal aspect to it in many different ways.
That's right, and I think there's been a good amount of research done on so-called street level bureaucrats, governmental bureaucrats, including police, who are different than other street level governmental bureaucrats in important ways, but also quite similar. And street level governmental bureaucrats tend to think about their work as a punishment in certain contexts. And there's actually a long history, and I situated in the paper, I situate no trial execution historically in the paper in this history, which tends to show that from the get-go, the police wanted to make sure that they distinguished themselves from punishers. They weren't going to usurp the judicial function of determining punishment. And I think that and others have suggested as much, they've failed in doing that. And so when we look at it from these three different vantage points, one, the vantage point of the person who's being punished, two, the vantage point of the punisher, and then three, the vantage point of the observer of these phenomena, we can start to see that there are really penal there's a penal streak that runs through this practice. And once again, if we look at it from this point of view, then it starts to the two kind of genres of of state killing collapse into one.
Well, and that's a really, like, the history you told of this kind of gradual professionalization of the police seemed to kind of parallel or even kind of be a motivation or way of accomplishing a way of enforcing state social control over certain populations.
That's exactly right. Couldn't have said it better myself.
Yeah, and I mean, what really hit me reading the paper was the way in which the more you think about kind of the increase in policing and the mode of policing as being the state trying to exercise coercive social control in particular contexts, the easier it becomes to see these kinds of extrajudicial no trial executions, as you put it, as on a continuum rather than being distinct from executions that take place after a trial, or really any kind of punishment when it comes right down to it.
That's exactly right, Brian. I agree.
Wow. I mean, so this was a really different way for me of looking at this problem. But I sort of wonder, I mean, to the extent we think of policing as you put it, kind of turning certain neighborhoods or communities into kind of de facto open air prisons where people are continually under surveillance and continually under threat of punishment. Like, how should that change the way we think about the state's role in, the way it affects the people living in those communities?
Well, the first thing that comes to mind is that we should probably get away from the idea that punishment only happens after there's been some kind of something that we would recognize as process, a trial or hearing or the like. Punishment can occur before any of that happens, and it certainly does in those the low income neighborhoods, what we call the black ghettos. It certainly happens, and this is there's some good theoretical work being done by Loic Waquan and others that shows that this is the case. So if we can get away from that understanding, then I think that the problem would come into better focus. But of course, with dicta in the Graham case that I mentioned earlier, it makes it very difficult because, of course, the suggestion there by the court is that punishment only happens after states have abided by the strictures of due process. So what happens when there's been no due process? There can be no punishment. So I think we do well to get away from that idea.
There's almost like a catch-22 there, in a sense, that only after you've been only after the state has decided to put you in the box that says you get process, do any of these sort of punishment-based protections seem to apply in a way that put meaningful restrictions on the state's ability to exercise discretion. And if the state chooses not to put you in the box or hasn't been forced to put you in that box yet, then the level of state discretionary action that it can take without being subject to limitations is just really vast.
I think that's exactly right. And while we're on this point, I think it might be a good idea to point out just that we need a way to intervene ex ante before the police subject someone to a no trial execution, because to my mind, the rule of a rule of law that offers only post hoc or after the fact kind of remedies when the state action results in irreparable harm is a rule of law not worth very much at all. So the one of the main ideas of the paper is to suggest that for there to be really for the state to at least aspire to rule of law, we have to have a way to intervene and actually a fair shot at succeeding, I think, before the state subjects someone to a no trial execution. And as it stands today, there's no way to do that.
So in the paper, you use a term called transformative proceduralism. And I think that my understanding is you're using that term as a kind of a big picture way of talking about the problem you were just addressing. Could you maybe talk a little bit about what you mean by transformative proceduralism and how you might see that as different from the more maybe sanitized or less transformative proceduralism that we might normally think of in a criminal justice context or any other context?
Of course. In short, transformative proceduralism is a project that employs procedure to transform by limiting the realm of possibilities. This isn't what Stanley Fish has called the thin proceduralism of liberalism. And by liberalism, of course, here I mean the political, philosophical experiment and not the contemporary political ideology. This proceduralism is a thick proceduralism. It's one that is politically rich rather than politically vacuous. It's a proceduralism that has been purposefully imbued with political ambition rather than one that's been kind of separated and disarticulated from politics. This political ambition is, to kind of get down to the nitty gritty, is to bring within the realm of legality the police killing. So in a word, the idea of transformative proceduralism is the idea that we can use procedure and the rule of law to bind police action in order to transform what the police do.
Mm.
So to put it a bit differently, the idea here is to stultify what certain modes of policing that end up with civilians being killed in the street.
So one thing that struck me about your use of the term and the way you deploy the concept was that, I mean, it does seem to me like the sort of the history of the last 40 or 50 years, or maybe even more, of capital punishment jurisprudence has had elements of transformative proceduralism insofar as many kind of procedural or quasi-procedural moves have been made in ways to sort of make it a lot more difficult to actually follow through with the death penalty. And yet in the pre-trial or no trial or fourth, fifth amendment context, that primarily Fourth Amendment context that you're sort of dealing with, or the context in which we think of as embodying Fourth Amendment issues rather than Eighth Amendment issues, it seems like the procedure has really gone the other way in the sense of like finding exceptions to what would otherwise be, or what kind of conceivably could have been, more robust protections.
That's exactly right, and this has been pointed out by some folks who have reviewed the paper in its early stages, that this is one of the dangers of suggesting that police killing should be subjected to Eighth Amendment interrogation, because of course, if you transform the one by linking it to the other, then you also transform the other. So one of the dangers here is that the court can make so thin, might render so thin the procedural protections that they may just be meaningless. On the other hand, the danger of not doing this is that you have, and last I checked, it's over 600 people that have been killed by the police just this year, according to Washington Post's fatal force tracker, which has some problems. But it's an incredible amount of violence being done unto civilians. So there are risks with this project, but there are risks that I think we should be willing to take.
Yeah. Yeah. Well, so maybe you could give a few concrete examples of what you think a transformative proceduralism ought to look like in this kind of context. I mean, what would it mean for courts and for the state as a whole to impose meaningful kind of procedural requirements on the police before they engage in the use of force in a pre-trial context?
Yes, absolutely. I should just note that I try to avoid thinking too much about administrability and the like, especially when it's, when it comes to a program that I see as being constitutionally required, because I found that the function of that kind of thinking is to limit the realm of possibilities only to the realm of the status quo. But I don't mean to dodge your question. I think there's a strong claim and a weak claim. The strong claim here would require, importantly, prior to any discharge of a firearm by police, the approval of an independent, disinterested magistrate after a trial on the merits. And the weak claim would require no trial, but some prior judicial evaluation. And once again, I try not to think too much about the administrability of the program, but this, of course, would be very, very difficult for police to abide by. But that's kind of how I think about it. There's, once again, the strong claim and the weak claim. But that's how we could bring maybe the idea or the concept of transformative proceduralism, excuse me, from heaven to earth.
Well, but I mean, it seems to me, I mean, if you take a really big picture perspective on it, right? I mean, the story of the Eighth Amendment, at least as I see it, is abolitionists, death penalty abolitionists, looking to the Eighth Amendment and Eighth Amendment values as a way of hopefully eventually bringing an end to capital punishment, right? But it didn't happen right away. In fact, it hasn't happened yet, right? At least not in a lot of places. And in any case, it was incremental, right? I mean, it went one step at a time, relying initially on a lot of procedural changes, and only eventually kind of in some places becoming substantive changes to the law. And so like, even though the project, the kind of, as you know, like the big picture project you're proposing seems like unworkable or unrealistic or unthinkable today. I mean, I'm sure it must have seemed unthinkable to a lot of people in the death penalty context as well. And yet in both cases, like, actually more so in the case that you're describing, nobody wants to see people being killed without a trial, right? I mean, there's no deliberation of any kind. I mean, it seems like the ultimate substantive goal is actually less controversial in some ways. It's just a question of how much do we want to defer to the state?
I think that's right. And, I just want to note parenthetically that, we had nationwide judicial abolition of the death penalty in 1972. But, this seems like it might be an opportune moment to maybe raise and address a concern that is likely to come to the minds of many listeners and eventually many readers of the paper. Some would worry that the program that I've outlined might leave communities more vulnerable to the so-called mass shooting. And I hear this concern often, and I really began engaging with it when I wrote, not to get too off track here, but when I wrote about the 30th anniversary of Graham v. Connor, which came down exactly 30 years ago on May 15th of this year. And I wrote that short piece, which discussed the case's long reach in the Black newspaper, the Charlotte Post, and revisited the case in light of the horrific killing of Dan Kearse Franklin by Charlotte police this past March. And I should note also that the facts out of which the Graham case grew took place first in Charlotte, North Carolina, which is why I wrote in the Charlotte Post. Now, on April 30th, about 2 weeks before the piece was supposed to be published, the horrific shooting at UNC Charlotte took place, where I think 2 people were killed and 4 were injured. And because I only had 800 words, I decided not to address that tragedy in the Graham piece, but it made it clear that this kind of argument would probably be the strongest one, at least in political terms, against my proposed program. But with that said, to my mind, the era of the mass shooting is exactly the time that we should be reimagining our approach to police violence. In my view, the police in the U.S., and they're, depending on who you ask, between 16 and 18,000, law enforcement or police organizations in the country, to the extent that they can be considered a group of institutions with shared commitments, considerations, and so on. They engage in deadly gun violence on a mass scale across space and time. And now, in this way, police as an institution and the civilian mass shooter have much in common. And I should say, I don't mean for that to sound overly polemical. As I said in the Washington Post Fatal Force Tracker, last I checked, and it was earlier this week, 689 people were killed by police in the U.S. this year alone. And it's important to highlight that this database doesn't include those who've been killed by police using tasers, attack dogs, horses, bombardment, or another method. But it's to say that there's a lot of violence being done unto civilians in the U.S. Frank Zimmering, who teaches at Berkeley Law, estimates that between 929 and about 1,200 no-trial executions take place in the U.S. in a given year. So in this way, the police perpetrate mass deadly gun violence and should be considered, in my view, in the same conversation as those so-called lone wolves, allowing for important differences between the two, of course. And when framed this way, it becomes clear that my project and that of those who wish to do away with mass gun violence are one and the same. And this is all to say, Brian, that when we talk about, deadly police gun violence on the one hand, and then mass civilian gun violence on the other hand, I think we make a crucial mistake. And that mistake is not recognizing that it isn't one problem uh, on this hand and the other problem on the other hand, but that the two problems actually go hand in hand.
Yeah. Yeah. I mean, it really struck me that in one way, sort of like the big picture elephant in the room in your paper, as it were, is that if we think about the police institutionally, we don't have to blame individual police officers for exercising poor discretion when they choose to use or not use violence, although I think we should in many circumstances, but we should think of the institution as making institutional choices to encourage or discourage the use of violence, and that the rules the institution sets for itself and the rules that the judiciary enforces on those governmental institutions in effect encourage institutional choices to engage in this kind of killing in a way that doesn't look like it's a choice, but it is.
That's right. That's right. We don't have to get to the culpability for the purposes of my project of the individual police officer, because if it's not that police officer, then it's the next one. As you say, the institutional kind of the way that the institutions have structured uh, so-called police community relationships have made it such that those relationships are susceptible, or the civilians that find themselves in those kinds of interactions are susceptible to this kind of deadly violence. So you're exactly right.
Yeah. Okay. Well, so Michael, I wonder if in closing you could reflect a little bit on something that I found really interesting about this paper and this project more generally, and that you've talked a little bit about earlier in our interview, but I'd like to hear you reflect on a little bit more, which is that you say in the paper that this paper engages with the law and engages with kind of the Constitution and with constitutional doctrine, but isn't necessarily directly about the law or the Constitution or constitutional doctrine, but kind of encouraging or provoking people to think about them in new and creative ways. And you actually used the word delight in the paper, which I thought was bold and really got me thinking as well, which I think is I hope with what you were tending. So I wonder if you could talk about that project a little bit as a legal writer, and how you think that approach to your scholarship informs the work that you're doing.
Absolutely. I think that when where we find death and destruction, we might also find delight, and the kind of delight that I envision and that I talk about in the paper is delight by challenging legal actors to rethink their approaches, delight by challenging law professors to rethink the doctrine and the like. But underneath the bevy of aims that I set out in the paper, um, that we probably shouldn't get into, there's kind of a desire to demonstrate a certain and different mode of engagement, a mode of engagement that's at once liberated from the more restrictive norms of legal scholarship and is also bounded by a legal principle that itself may liberate. So this is what I try to demonstrate throughout the paper. But whether or not I've succeeded, or indeed whether or not it's this is a worthy undertaking, is something that I leave for commentators and my colleagues to evaluate.
Well, I can say that it certainly got me thinking a lot, and I learned a lot from it, and it really changed my perspective on the questions that you were posing in ways that I hadn't anticipated before I started reading it. So I appreciate it a lot, and I can't wait to read the final draft.
I can't wait either. Thank you so much, Brian. It's been a delight.
they come. Hippity-boop, the man in blue. Hoppa-da-bop, the sergeant's there. Ribbity-bip, the patrolman too. Hoppa-da-bop, the chief looks great. Hoppa-da-bop, the captain's straight. Ribbity-bip, hip-hip, hooray. The royal crew. Hoppa-da-bop-da-bop. You always try to swing with a policeman. And never ring-a-ding a policeman. And if you're really hip, you'll never make a slip against their majesties, the policemen.